Hello, and welcome to another week of Evidence Law. I am Jason Chin, your instructor, and this week's class is about what we call discretions, but as we'll see is a bit broader than that. Alrighty, so just to catch you up on where we are, we've already talked about the rules of adducing evidence, the rules about determining if evidence is relevant, and then we've gone over several exclusionary rules. So rules that, despite the fact that the evidence is relevant, can be used to exclude that evidence. And the rules this week are really sort of your final recourse. You haven't found a specific exclusionary rule that will deal with your evidence, or you haven't met the requirements of that exclusionary rule, but you still think that this evidence should be excluded for some reason. So in a lot of ways, it's like the light of Arundel, which you might recall Galadriel said, "And for you, Frodo Baggins, I give you the light of Arundel, our most beloved star. May it be a light to you in dark places when all their lights go out." Your last resort when you're facing down Shelob, the spider. So I have 3 parts for these lectures. The first part is to discuss what is probative value and how is it assessed. The second part will be about what is the unfair prejudice that's often on the other end of this balancing rule that we look at. And finally, section 138, which is slightly different than the first 2, in which it's more about this evidence has been obtained illegally or inappropriately, and should it be excluded for that reason, or can it still be admitted? So that should say part 1. So for part 1 today, the outline is as follows. First, we'll quickly go over the main rules that we look at in this category of rules, sections 135, 136, and 137. Then we'll talk a bit about what the authorities tell us about how to assess probative value. Can we take the reliability and credibility of the evidence into account when assessing probative value? Can we take the fact that this evidence might sure lead to the inference of guilt, or that some fact and issue exists, but it also might have lots of other inferences that flow from it that are perfectly innocent. Is that a reason to say this evidence has less probative value? Then I'll talk a little bit about how we might think about probative value when it comes to different types of evidence. Does the way in which we assess probative value vary depending on the nature of the evidence? So first the rules. The two major ones that we see invoked quite a bit are section 135 and 137. Section 135 is the general discretion to exclude evidence. And 137 is for the specific circumstance in which it is evidence that is tendered against the accused in a criminal proceeding. And the rules are slightly different. 135 says the court may refuse to admit evidence if its probative value is substantially outweighed by the danger that the evidence might be unfairly prejudicial, be misleading or confusing, or cause or result in an undue waste of time. Section 137 says in a criminal proceeding, so we're already narrowed into that specific type of case, the court must. So here you might think this rule is not really a discretion at all, it's mandatory. the court must refuse to admit evidence adduced by the prosecutor. So this is only evidence adduced by the prosecutor, the Crown typically, if its probative value is outweighed by the danger of unfair prejudice to the defendant. So this one is much more forgiving to the accused because you're not requiring that the probative value be substantially outweighed. It just must be outweighed to any extent. Could just be by a hair, and the court must refuse. It's not a discretion, so to speak. What about evidence adduced by the accused? Courts have said that, of course, 137 is irrelevant because it's not being adduced by the prosecutor, but also that courts should rarely invoke 135, despite the fact that it would notionally cover these circumstances. I suppose the underlying rationale is one of fairness. You want to give the accused every opportunity to prove their innocence. Should have a broad right to make full answer and defense. Right, what about section 136 then? So section 136 is similar, and it's not for the full exclusion of evidence, but just for a specific use of the evidence. So the evidence would still get admitted for one use, but not another. We've sort of talked about this, but I'll elaborate a little bit more. The court may limit the use or use to be made of evidence if there is a danger that a particular use of the evidence might be unfairly prejudicial to a party or be misleading or confusing. So we often see this invoked in the context of section 60, which, as we talked about, is the rule that evidence that would maybe otherwise be hearsay evidence can be admitted for the truth of its contents if it has a non-hearsay use. For instance, if it has a credibility use or a use to prove the basis of an expert's opinion. If you recall, I think Quick and Stolen and Django and the Northern Territory. So as I mentioned, as we mentioned then, this can be a very powerful rule here, because you're taking evidence that otherwise, if not for this rule, wouldn't have been admitted for the truth of its contents, but because of section 60 allowing that. So in the case of Django and the Northern Territory, the evidence was admissible under section 60, but the court used the rule in 136 to limit the use of that evidence. So in that case, the expert had done a bunch of interviews about I believe, the historic use of the land in an Aboriginal title case. And because those interviews were being tendered to prove that he had done this research to prove the basis of the expert opinion under section 60, it could be used for the non-hearsay use of the actual truth of the interviews, which you can imagine that could become quite prejudicial for the other side, because now they have all these interviews being admitted for the truth of their contents, which are very difficult to cross-examine. Essentially would kind of overwhelm the other party with all of this research they'd have to try to find a way to confront. So the court said it could only be used to demonstrate the basis of the expert's opinion and not for the broader use that these interviews are true. It doesn't have to be in the context of section 60, so it can be used more generally. In Ku-ring-gai and Chia, there was evidence of mobile phone data, and it was allowed in for the use of proving that the person's phone was within Sydney, but it was not admitted. It was scoped under Section 60 to be admitted only for that purpose and not as evidence of the person's precise location. So we might ask then, what kind of rules are these? We like to think about the purpose of these rules. And in one of the first lectures, David mentioned there's different categories of these rules: factual accuracy, efficiency, and fairness. And you can sort of come to your own conclusions about this. But for me, depending on the rule, these invoke all three of these concepts to some extent. In terms of accuracy, because we're looking at probative value, evidence's ability to prove a fact and issue, it seems like we are thinking about excluding evidence that is maybe not as useful to prove facts. So maybe there is some notion of factual accuracy there. In terms of excluding unreliable evidence, we'll see that's a bit contentious. But it seems like to some extent these rules might be used to exclude unreliable evidence, but it's not so clear. Efficiency, it seems like some of these rules directly invoke the idea that evidence that has low probative value, but will take a lot of time to explain, that can be a reason for excluding it. So it seems like efficiency is part of this. Is part of the rationale for these rules. And fairness, I think, as we'll talk about, especially in the context of 138, but also when we talk about unfair prejudice, some of these rules are excluded because, well, in the context of Section 138, because they were illegally obtained, and maybe that's unfair to the accused, or they might be unfairly prejudicial in that they arouse the fact finder's emotions to the extent that it overwhelms their rationality, therefore should be excluded. I suppose there might be another one in which you might consider to be constraining public authority. So with Section 138, as we'll discuss, we don't want to encourage them, in fact, we want to discourage them from acting illegally, acting inappropriately in obtaining evidence, because we expect public authorities like the police to be honest and to have a positive example for how people should behave. And so the courts can kind of do a slap on the wrist for police when they get out of hand in Section 138. But let's talk about probative value. That's the first part of this balancing act for many of these rules. What does it mean? So we talked a little bit about this in the first class, in the first tutorial, but probative value is defined in the definition of the act to mean the extent to which the evidence could rationally affect the assessment of the probability of the existence of a fact and issue. This has led to the sort of very contentious question of, does this require that the trial judge must assume that the fact finder will find this evidence credible and reliable? So if you recall that, I mean, that seems to be certainly the case when it comes to the very similar section of relevance, the very similar concept of relevance. And you might recall that in that first tutorial, we sort of talked about probative value being the degree of relevance. How relevant is something is essentially its probative value. Because some things will kind of meet the on-off switch of being relevant or not, but we would probably agree aren't very relevant. We talked about a little bit in that first tutorial about somebody hearing from, a few kilometers down someone's scream one night. And is that relevant? Yeah, maybe, but it seems like it has very low probative value. And we can kind of see that in that the test for relevance says if it were accepted. So this is the assumption that the jury will accept the contention of this evidence. And this is also supported by the fact that probative value says extent. So it seems like it's talking about the degree of probative value. So there seem to be some pretty clear textual differences here, but as to whether these textual differences allow the trial judge, when assessing probative value under section 135, 137, and to some extent 138, to get into, should they assume that the jury will find this evidence to be maximally reliable and credible? Should they assume that the jury will accept what's being pled about this evidence? That could go both ways, right? You could see the word if it were accepted and under relevance, but not under probative value, to think, okay, maybe you should assume that the jury will accept the evidence's credibility and reliability for section 55, but not have to do that for the probative value assessment. Or you might think, well, the word could is in both. So we're talking about the extent to which evidence could rationally affect, which seems to include an assumption of this is all that it could do. We're looking at its maximal value because of the word could. It's not so clear. But I have this little exercise here that might help. So here's 4 examples of evidence, and it might be helpful for you to think about how probative is this evidence. From 1 to 5, 5 being highly probative. So the first is the accused voluntarily attended the police station and confessed. For me, this seems to be pretty probative of whatever fact and issue it's being tendered to prove within reason, because why else would the accused do that? It seems to be pretty clear, direct evidence requiring very few assumptions that there is some sort of guilt here. This can be contrasted with the accused confessing after 4 hours of intense interrogation and sort of threat to investigate the accused's wife. Might be lower here intuitively for sure. As to why, that might be up for debate. You might say it's less reliable, it's less trustworthy, possibly because when people are threatened and when they're sleep deprived, you can't really trust the words they're saying as much. And so is that a permissible reason to say evidence has lower probative value is an important question, I think, and one that we'll have to confront in this class. The accused bought a new car 5 months after alleged robbery. Again, this seems to, at least to me, be intuitively weaker evidence. And the accused, because there's people buy cars all the time. If you had just stolen a car, if you just done a robbery, wouldn't you use the proceeds from that more quickly? If it was right after the fact, it seems like a stronger inference. Then you might argue, it makes sense to wait. You want to wait until things have cooled off before you start spending this money. So it's not so clear. And somebody apologized after an accident. Again, lots of reasons someone might apologize. Is it an admission of guilt? Is it not? Certainly seems to have some probative value, but as to how much, probably not that much. So the Queen and IMM is our key case in this area about how we assess probative value. It arose because there were two different approaches in New South Wales and Victoria. XY, paradigmatic of the New South Wales approach, which said that trial judges should assume that evidence is maximally credible and reliable when assessing its probative value. Whereas the Victorian approach, exemplified in Dupas, was that courts should assume that the evidence is credible. Judges shouldn't be getting into credibility. That's kind of what the jury's there for, is to look at the witness and determine if they're telling the truth. But judges can take into account reliability. And that was sort of the basis for that case Toot that we talked about, which said that you can take into account expert evidence's reliability when determining whether you should exclude it under section 135 or 137. Now, you're all probably, it's those of you who are working on your essay right now, or you'd have to be, I guess, watching this video right when it drops for that to be relevant, but you might be. And so you might be thinking about, how is this relevant to the roles of the trial judge and jury? I think these conflicting approaches and the eventual resolution in IMM is entirely about what the High Court and Victorian courts, the New South Wales courts, thought about the proper role of the trial judge versus the jury. Question seems to be, should the judge wade in when it seems that the evidence is not reliable, or perhaps its reliability is questionable or unclear? And in cases like that, shouldn't let the jury hear this. It's too dangerous for them to hear this. Or should, as the New South Wales courts and now in IMM, the High Court determined, maybe we should be more deferential and trust the adversarial processes. Trust the adversarial system to uncover the weaknesses in the evidence, and trust the jurors to assign the proper weight to the evidence. And it is not the role of the trial judge. The judge should be an umpire, rather, and not wade into the fray. So as I mentioned, by a narrow 4-3 margin, the High Court followed the New South Wales approach. And they did this for three main reasons. One is the text of the act. Second, finding that the pretty clear language in the Australia Law Reform Commission report was inapplicable. And that the more policy or philosophical approach of the trial judge should be hands-off. And just as an aside, you can also see paragraph 35, where it did seem at common law there was authority under the rules that would the common law discretion to exclude. In this case, Christie, in which cases using that, sometimes called Christie discretion, would take into account the would take into account the credibility and the reliability of the evidence. But here the High Court said common law, as you saw in section 9, the common law could still exist unless it's expressly overruled by the statutory language, and here the statutory language is clear. Although, 3 judges disagreed, so query how clear it actually is. So as to the text of the act, we've kind of already covered this, but there seem to be these differences which militate towards judges taking into account credibility and reliability, but the majority was not convinced by that. Because it says that we're really interested in this word could rationally affect. Could implies the possibility. Its ability to, not how much it actually does. So we should not look at credibility and reliability. And the word extent is does not import new and different considerations. So it was not impressed by the word extent there. The majority was also not impressed by the Law Reform Commission report stating that the reliability of the evidence is an important consideration in assessing probative value. There, the High Court seemed to say, well, because it was thinking more about section 137 and 97 in this case, said that the Law Reform Commission report there, this quote is from when they were discussing section 135. So that really isn't relevant to this case. Now, the problem with that is that this case has been read to go beyond 137, 97 to 135. So this decision actually is affecting evidence that the Law Reform Commission pretty clearly said reliability should be taken into account for. And it's really hard to think of a good reason why you would approach probative value differently in 135 and 137. So this to me is not that compelling. I think the most compelling reasoning the majority gave was that oftentimes it's hard to assess the probative value of evidence until you've seen the entire case. Therefore, the judges will not be in a good position when this evidence is tendered earlier in the case to really understand how it fits in the whole complexion of the case. So that was their reason for saying it would be inappropriate for the judge to really try to assess the credibility and reliability of this evidence at a stage before we've seen what other evidence is really out there. And in fact, the jury is better placed to be making that assessment. You know, that's good reasoning in my view, but there will be cases in which you can tell, like it won't matter what else is tendered, and this evidence is plainly, unreliable. So good reasoning, but it's maybe a little overbroad. That said, the High Court seemed to anticipate some evidence in which it should still be excluded under 135, 137, or even Section 55. One category was evidence which is inherently incredible or fanciful or preposterous, such that it's not even relevant to begin with. It's not even some bare level of probative value, which I guess you could think of some pretty outrageous evidence that might fit into that category. So that sounds pretty narrow. There's one that might be broader, though, and I think is worth discussing a little bit more. It's also a bit more puzzling. So it says that, this fact that we are taking reliability and credibility at its highest, assuming the jury will accept its reliability and credibility, does not distort a finding as to the real probative value of the evidence. It goes on to say, the circumstances surrounding the evidence may indicate that at its highest, it's not very high at all. And there's an example from a speech of a former judge of an identification made very briefly in foggy conditions and in bad light by a witness who did not know the person identified. And so there were two approaches to this evidence that we think the High Court seems to think should be excluded. One approach is to take this evidence at its highest and then look for particular weaknesses in this evidence, which would include its reliability. And you might want to read this yourself because it is genuinely a confusing set of reasoning. On another approach, it is, and this is the approach, so that earlier approach was the Victorian approach, which we're not following anymore. On another approach, it is an identification, but a weak one. because it is simply unconvincing. And that's the New South Wales approach. That's the High Court approach. And that's the approach that they say the statute requires. So that evidence should be excluded because it is simply unconvincing. It's weak because it's unconvincing. And what are these factors that make it unconvincing? It seems to be some of those estimator factors that we looked at for unreliable identifications. Bad viewing conditions, bad light, and someone that you were previously unfamiliar with. So things that that you can't change in the system, like the lineup, but just factors that go to your ability to recognize and see somebody and remember them. Now, the kind of puzzling thing about this, and I'm not sure there's been really a strong resolution to this, is that those are all factors going to the reliability of this identification. It's weak, it's simply unconvincing, but it is those things because it's not reliable, because there are many factors that affect the person's memory here. Their ability to remember and report the person they saw. That's reliability. So it's simply unconvincing, sure, because it's reliable, but we can't actually talk about reliability. We just have to say it's simply unconvincing. It's kind of strange. It's really hard to parse that. So here we can look at different types of evidence in light of IMM. And we talked a lot about how do you assess the probative value of tendency and coincidence evidence in those cases, because the exclusionary rules are wrapped up in that assessment. And we looked at things like the similarity of the events, the similarity of the previous acts to the charged act, the number of previous events, and those factors make something more probative. And that reasoning still seems to be completely on the table after IMM, of course, with the limitations of the child sexual offenses provisions, 97A. But with the more direct evidence, like evidence of an identification, those factors that we saw as going to reliability, like not remembering other race faces as well, a suggestive lineup, a show-up procedure. Those are all factors going to reliability classically. They seem to be off the table, but after IMM, but then there's this kind of carve out or narrow or possibly broad exception to that, which is evidence that is simply unconvincing. We do have a couple of identification cases post IMM. We'll take a look at one, which is Bailey and the Queen Victorian case, which you might recall has typically taken a more interventionist trial judge approach. But in this case, the impugned evidence was an eyewitness identification with many of these factors that we are typically concerned about. It was, the identification was made off of Facebook, so it's basically a show up, only one person to choose from. There was a long delay from the event to the identification. Lots of elements of suggestion in that the complainant knew that the person that they saw on Facebook had been charged with a different crime. Various other factors that I won't get into. So these seem to all be factors that go to the reliability of the identification. And the court goes through that. They say, yeah, well, we used to have this approach in Dupas, which didn't require the assumption that the jury would accept the evidence as reliable. paragraph 50, but the High Court seemed to change that. But the High Court also gave us this rule of simply unconvincing evidence. And so adopting that approach, we're going to say that this evidence is simply unconvincing. With very little actual reasoning. You just either fit into that category or not. Do we know anything else about this? So let's take a look at this case, Debrase. And as I've seen in the post-IMM case law, there's a real challenge in trying to interpret what simply unconvincing means. In Debrase, which I think is most explicit in this struggle, the court was confronted with what seemed to be a pretty unreliable, not identification. So taking it out of the identification context, one thing you could perhaps do in Bailey in cases like that is to say, okay, well, we don't know what simply unconvincing is, but this sounds like that foggy night situation. So by analogy to an analogy made and by the High Court, we can exclude this, even if we don't really know what simply unconvincing actually means. That per se wasn't an identification. It was a pre-recorded witness statement about something that happened 10 years ago, not about an identification. So here the court, the Victorian court expressly is trying to extract a principle from that idea of simply unconvincing that it can take more broadly. So court says, okay, while the example was about an identification, I can see no reason why it can't have a more general application. If the impugned evidence comes from an impeccable source, but by dint of circumstances in the surrounding evidence, its probative value is not very high at all, then it might not, even at its highest, it might not be worth very much. So it's saying, okay, so there's something more than simply unconvincing, there's something more than the foggy night, it's about the surrounding circumstances. Unfortunately, then it kind of goes on to say what is it about those circumstances? And it gets into memory factors again. It says there's the risk of contamination in this case. There's the age of the child in this case. So we're still really moored to those factors that came out of that foggy night example. In that case was not even about a foggy night. IMM was a tendency and coincidence case. So trying to figure this out going forward is a bit fraught. The logic seems moored in that example that was given. Maybe you look to the surrounding circumstances. It has to be pretty extreme, it seems like. And to me, this illustrates, and to me and others who've suggested this is a problematic holding because it relies on an adjective, simply unconvincing, instead of providing us with any sort of principle or guidance about when we should be excluding evidence. Hopefully maybe this will change. It was a 4-3 decision. So finally, in probative value, let's take a quick look at Sood, case about when evidence has competing inferences. So this was allegation of a doctor kind of cooking the books when asking for money from the public health system to cover their number of patients they've seen. And they found a bunch of her financial accounts in the waste bin, and they wanted to use that as evidence of consciousness of guilt, that she was trying to throw away, trying to dispose of the evidence. And one issue that was, when arguing this as low probative value, could you take into account other inferences, like accidentally falling in the trash can, or there being many reasons why you might throw your financial accounts away, not necessarily consciousness of guilt. Court of Criminal Appeal said no. It's not part of the trial judge's function to assess competing explanations. Seems like a further restriction in our ability to find something that has low probative value. Now I'll end up this lecture, which has gone a bit long, so as with the last week, I'll try to condense the next two. With a little note on the child sexual offense amendments that we talked a little bit about, and the tendency and coincidence classes. So if you recall, section 97A says we should presume significant probative value for the purposes of section 97 and 101, but it doesn't mention 137. However, if you go into the Royal Commission's report, they say that tendency evidence or coincidence evidence about a party that is admissible under this part cannot be excluded under 135, 137. But I can't find that language anywhere in the amendments, the actual amendments that came about. So unless I'm wrong about this, it seems like evidence that gets through 97 and 101, which kind of constrain the probative value assessment quite a bit to make evidence constraints what you can look at as you presume probative value. Those constraints that make it much easier to admit tendency and coincidence evidence in child sexual offenses cases seems to still, those restrictions don't seem to be in 137. So that would seem to be almost defeat the point of those provisions if it is excluded there, but right now I can't find any reason not to. So it's maybe something to be aware of, and maybe there'll be some further activity here, or maybe there's something I'm missing. Alrighty, we'll take up part 2 momentarily. All right, everyone, let's move on to part 2 of week 8, which is the really second half of the equation, the unfair prejudice of the evidence. For some elaboration on what unfair prejudice is, and to be clear, I think unfair does a lot of work in this phrase. It's not enough that the evidence be prejudicial. By some definitions, most evidence tendered against you is going to be prejudicial to your case. It's got to be unfairly so. You can see one elaboration on this in the Australia Law Reform Commission report, saying that the risk of unfair prejudice is one of these potential disadvantages. And by risk of unfair prejudice is meant the danger that the fact finder may use the evidence to make a decision on an improper, perhaps emotional basis. In other words, on a basis logically unconnected with the issues in the case. This evidence that appeals to the fact finder's sympathies, arouses a sense of horror, provokes an instinct to punish, or triggers other mainsprings of human action, may cause the fact finder to base its decision on something other than the established propositions in the case. So not merely, the fact finder is not merely reasoning from the evidence to the opposing party's preferred conclusion, but doing so in a way that it exceeds that evidence. They're misusing that evidence in some way. So perhaps easiest to look at in terms of some examples. So we often see unfair prejudice invoked in cases in which the evidence involves providing the fact finder with some knowledge of some other illegality, some illegality that's not currently at issue. So we'll see that in the case sued that we'll talk about later. And we've also seen that in almost all the, or most of the propensity cases that we looked at. So we're talking about illegal or unsavory acts that are not the actual charged acts. So there's the risk that the fact finder will reason from these allegations that are not currently, that from these acts that aren't currently the substance of the present allegations, punishing the accused for a crime that they are not currently on trial for. We see this in the case of perhaps gruesome or disgusting evidence that maybe is tendered to be prejudicial in the sense that it is evidence of the extent of the harm that was done, which would be relevant. But it also might arouse other feelings that would just, in theory, inflame the fact finder to finding guilt when in fact, or to place more weight on that evidence than is deserved. It might place the accused in some sort of forensic disadvantage or some other sort of disadvantage. So you can look at the case DL, in which the similar fact evidence, the propensity tendency evidence, was of uncharged acts in the Australian Capital Territory, but were currently charged acts in Queensland. So in defending this case here, in being forced to respond to the tendency evidence, there was the concern that the accused would have to provide evidence that would be prejudicial against them in their Queensland case, which might be unfair. And one thing to note, and I would say most of these cases, but I don't really have any empirical evidence for that, but at least anecdotally, in the cases I look at, you almost always see the argument that any unfair prejudice can be mitigated, and this is often a winning argument. Any unfair prejudice can be mitigated by trial safeguards, typically some sort of instructions to the jury to only use the evidence for the stated purpose. So you can use this as evidence of their tendency to do something, but you should not be misusing this to punish them for the previous crimes. Those are not on trial here. They've already been resolved. One of the recommended readings was a psychology article, because this is in a lot of cases an empirical question. We can actually run controlled studies to see if providing more emotional evidence that conveys the same probative value, the same actual, has this evidence, the fact that it's gruesome or not gruesome provides the same information. So we can control for that. We can control for the relevance issue and manipulate how emotional it is. And does that actually affect people's decisions? If it does, you could argue that there is an empirical reason to think that evidence is unfairly prejudicial. And more generally, we know that emotion does affect decision-making. Maybe that's not surprising to most of us. Emotional information draws our attention. The feeling of disgust makes us more inclined to punish. Angry people decide things more quickly and more on the basis of mental shortcuts rather than logical reasoning. And we know that in some of these cases, in some of these studies I've talked about, that disgust and anger can affect jury verdicts. With most of this research, you have to adjust maybe your conclusions based on the fact that these studies are not often done in the context of a real trial, because you can't actually do studies in the context of a real trial. So they're often done in mock jury studies. And some of them aren't that close to how actual juries decide things. So there's lots of delays in an actual trial from when you see the emotional information to when you decide the case. And you might think that that delay is time such that the emotions can dissipate. So when your actual decision occurs, there isn't as much emotion. Also, there's in actual juries, there's short to long deliberation process. It's quite variable, and perhaps the process of talking it out can help help mitigate some of the effect of emotions. And the article I had you read, I thought was a pretty cool one in which the evidence is presented both in black and white and color. And so what Jessica Salerno did in that study was she presented the participants with these gruesome photos. Some saw it in color, some saw it in black and white. And she found that the color photos increased disgust, and that disgust was correlated with increased guilty verdicts. But there wasn't the same effect for the black and white photos. But they get the same information across, right? So it could be a useful tactic in real life you can give the jury the same information, just sort of tone down the color, tone down the emotion, and you avoid some of the problems of unfair prejudice. So we'll go through a few cases about to think through to demonstrate how courts think about unfair prejudice. One commonly evoked unfair prejudice is the inability to cross-examine evidence. And so the argument there would be that this evidence is unfairly prejudicial because I can't test it. So it's being used against me in a way that I can't actually confront and show the fact finder the weaknesses of it. So therefore it will be used against me in a way that's unfair. So we can look at this case, Ordukaya and Hicks, and this is exactly that type of case. So it's a civil case, so we're talking about Section 135, and it's about the negligence in the paving of some staircase, and the plaintiff wanted to bring the evidence of the defendant wanted to bring evidence of this older person through the hearsay rule by affidavit instead of in court. And the issue was, did the plaintiff, was this unfairly prejudicial because the plaintiff couldn't cross-examine this 92-year-old person? Civil cases, we are more lax, as you know, about the hearsay rule. And here the court said, well, this is pretty much exactly what Section 64, the exception, contemplates. So this potential prejudice was contemplated in the act. So you're going to need something more to say that this is unfairly prejudicial. Moreover, it says that this lack of ability to cross-examine, the fact finder can understand that and be instructed about that. They can be told, or the judge can take into account that this hasn't really fully been tested, so there could be some weaknesses to this that weren't explored. Another possible unfair prejudice is the results of other proceedings being brought into a later proceeding. Perhaps the fact finder would be overly swayed by the fact that there was a decision made about a very similar occurrence in a previous case, and the fact finder would just adopt that previous decision and not really evaluate the facts of the instant case. And there could be some sort of procedural unfairness, some sort of procedural disadvantage resulting in unfair prejudice from not being able to have been the party who tested the evidence at the previous proceeding, or not having a chance to have actually cross-examined it at the previous proceeding, and now it's being tendered against you here. So for that issue, we can see Ainsworth and Burden, Court of Appeal case in 2005. And I believe it was a jury case because it's a defamation trial, one of the few civil cases that's heard by a jury. So the defendant is a former police officer who just really seemed to have it out for this particular, I think, gambling business, casino or something like that. And it just really seemed to have some sort of vendetta against this company. And so even after retirement, published a letter about how this company should not be allowed to have poker machines. It's a bad company. It's a bad business. And initially one of the defenses was that it's true. B is unfit. Sorry, A is unfit. And so what A does is tender 5 decisions of this licensing court in which the police officer was involved earlier, which all found that A was a fit and proper person to have the gambling license. So this is relevant. You can see this is relevant for a couple different reasons. One, perhaps for the truth of that finding, which is that A is fit and proper, but also to show this pattern of this sort of vindictive behavior, that B really does have a vendetta against us because B was involved in these prior allegations. And they kept losing then, they're losing now, keeps pushing this. There's really this sort of motive here to come after us. And B says, sure, okay, maybe it's relevant for those reasons, but it's unfairly prejudicial because the jury might substitute those previous decisions for their own. Say, so we don't have to decide this because it's already been decided, which might be especially true when it comes to the fit and proper conclusion, because that's was at issue then and seems to be at issue now. So at trials, this is the appeal, the trial judge agreed with B and said, I think it's practically impossible for a jury to put it out of their mind when they decided the truth or otherwise of the suggestion that the plaintiff is not a fit and proper person, that 5 courts, or perhaps 1 court on 5 occasions, had found that he was fit and proper and rejected a number of the issues raised on defense here. So this failed an appeal for a few reasons. One was that eventually when the truth of the allegations was no longer at issue, there really wasn't much of a risk for misuse because that's what they were worried that the jury would substitute. And once that wasn't at issue anymore, that wasn't as much of a risk. Second, it was, the Court of Appeal said this is actually quite probative of malice. It really has high probative value. That's not really, we're talking about unfair prejudice now, but it was strongly probative of malice involved. And the Court of Appeal, as in many cases, put a lot of faith in the trial safeguards. It says it's very easy to give a strong direction to the jury that they shouldn't be about what use they can use for this evidence. And we trust that these instructions will work. As mentioned, there was also this argument about a procedural disadvantage. And the court wasn't convinced of that either, in part because this B was actually involved in the earlier proceedings. So B did have a chance to test some of this evidence at the earlier proceedings. So we talked about Sood already. This was the good Dr. Sood, whose financial records were found in the waste bin. There we learned that probative value should not take into account competing inferences from that. But how about the issue of unfair prejudice? So here the trial judge, the trial judge's decision here, as in Ainsworth, was overturned. The different trial judge, I should imply it's the same trial judge. The trial judge's decision was overturned here, and the trial judge's original reasoning was that, well, so one of the other reasons that's being alleged that these financial documents were attempting to be destroyed was that the accused said, "Oh, well, I'm also under investigation for tax fraud," and that's my reasoning for why I'm trying to destroy this. And therefore, by now adducing this evidence, you're forcing the accused to explain that they're under investigation for tax avoidance. So it would require an instruction to the jury that, oh, like, so they've had to say that they're under investigation for tax evasion, but put that out of your mind. This is not a case about tax evasion. It's about defrauding the medical system. And you might think those are very similar things, so it'd be very hard to ignore that. Court of Appeal here says, no, we trust that these instructions will work. Juries can understand them. And in fact, fear of tax investigation and prosecution is one of the few experiences capable of being appreciated by a large member of the community from which juries are drawn. We all understand what it's like to be under investigation from the tax authorities. This is very relatable. Maybe, I mean, this is not in there, but maybe it makes you a little more sympathetic. As also to unfair prejudice, let's take a quick look at a case that I cannot pronounce. Tugral. Here, there might be some unfair prejudice in the way in which science was communicated by one of the expert witnesses. So it was provided in two ways. So although DNA evidence is typically provides a pretty high level of certainty, there is still always some uncertainty. There's still some risk of a misidentification. And it was presented in two ways. One, as a frequency ratio. So the jury was told that 1 out of every 1,600 people share this profile. So that's the probability that you are matched, that you get a match when in fact you are not that person. You just happen to share the same DNA profile. And the other was presented as an exclusion percentage, so saying that 99.9% of people do not have this DNA profile. And the argument here from the accused was that exclusion percentage was prone to misuse from a jury because the jury might think 99.9% is basically 100%. I can convict safely. So that should have been excluded. Whereas the 1 in 1,600 kind of makes more salient. 1 in every 1,600, there's an innocent person being convicted. That makes it be clearer what it makes the possibility of error more immediate and more obvious. So the High Court was not convinced by this. Said first, yeah, you didn't. I guess you could have led some expert evidence about people's likelihood of misunderstanding these two, but right now that's kind of all conjecture. One of the other arguments was that, and I thought this was actually pretty strong from the accused, was that just giving that exclusion percentage doesn't add anything. So the probative value is basically nothing. And the probative value and the prejudice is quite high. High Court rejected all of those. They said, first, if you look at the transcript, the expert made it clear that these meant the same thing. So because they did that, it's less risky. Explain how it was derived. But we do tend to agree that these do sound different, but at least the expert explained that. So we shouldn't, I suppose what they were saying is you shouldn't approach this 137 unfair prejudice assessment in the vacuum. You should look at the entirety of how this evidence was presented. One judge said something that I think is sort of plainly ridiculous, saying that on any criminal jury of 12 is likely to contain at least one juror capable of realizing this equivalence and demonstrating to the other jurors that the frequency estimate was the same as the exclusion percentage. So when we talk about using a light hand when it comes to, I mean, it's wrong terminology in the context of this judge, but the courts being very reluctant to exclude evidence under these provisions. A lot of it, as we talked about in the last class, is driven by a sort of trust of the jury and trust in the adversarial system to expose possible misunderstandings. And that seems to be taken to the 100th degree in this quote here. So we'll finish up now with the next part, the final part, section 138. All right. Let's finish up this week by talking about sections 138 and 139. Illegally and improperly obtained behavior or evidence. These are cases in which, these are rules in which the notion of unfair prejudice isn't really present. Instead, we're looking at the seriousness of the impropriety or illegality in obtaining the evidence. We'll be looking at sections, and this is also the sections, the class in which I've become the most aggressive in using Bitmojis. So that's just something we're all going to have to deal with, possibly forever. Section 138 and 139. So where 138 is the discretion to exclude illegally or improperly obtained evidence, and section 139 provides some circumstances in which evidence is considered to be taken with impropriety. Let's move on to a bit of background. So section 138, you can think of as being theoretically different than 135, 137, and that its factual accuracy, efficiency are taking a backseat to the more extrinsic notion of public policy, the degree to which the court wants to express approval or disapproval of the behavior of the party that collected this evidence. So we're not really interested in factual rectitude here as much as rectitude. The rule can be traced to the High Court decision in the Crown in Ireland, which it was concluded that a trial judge should have excluded evidence, which were photographs taken of the accused hands without his consent, among other things. Chief Justice Barwick held evidence of relevant facts or things ascertained or procured by means of unlawful or unfair acts is not, for that reason alone, inadmissible. The trial judge has a discretion to reject the evidence. Continued to say, convictions obtained by the aid of unlawful or unfair acts may be obtained at too high a price. So we may have got to the right decision. We're not really discounting that this is valuable evidence, but we should not be condoning this type of behavior, which, if it continues, might cause people to lose faith in the justice system. This was later picked up by the High Court in Bunning and Cross, which is still the leading common law discretionary exclusion for illegally obtained evidence. So if you were in Queensland or South Australia, or other common law jurisdictions, you would plead this instead of Section 138, of course. And in that case, the court further elaborated on some factors that go to whether this was bad behavior by the Crown, or the police rather. And many of these factors were picked up by the Australia Law Reform Commission in developing Section 138, which, as we'll see in the 2020 decision of Kadir, is still being fleshed out, still being figured out by the courts. 138 is, I think, as you'll see in Kadir, wider. Well, we already knew this, but Kadir explains this. It is wider than the Bunning Cross discretion. For one, it's not confined to criminal proceedings as Bunning Cross is. And it's not only for evidence that's obtained by misconduct of law enforcement. A lot on here. I'm not going to go through every one of these provisions, every one of these subsections, but first thing to note, subsection 1, it's really the heart of the discretion. It says evidence that's either A, obtained improperly, or in contravention of Australian law, or in consequence of an impropriety or contravention. So down the line, it is the evidence was obtained through a series of events that started with a contravention of Australian law or impropriety, is not to be admitted unless the desirability of admitting that evidence outweighs the undesirability. Subsection 2 clarifies that improper confessions or improperly contained confessions are improper, and gives those some of the clarification on that. And then subsection 3 provides many of the factors that you can look at. Then section 139 provides the way in which witnesses should be cautioned to avoid impropriety. Subsection 1 requires a caution that the person doesn't have to say anything, and anything they say may be used in evidence when that person is under arrest. Subsection 2 requires caution if the person is not under arrest, but the officer believes there is sufficient evidence the person has committed offense. The rest of them further explain that, and I'll leave you to read those on your own. So a couple of cases to illustrate this too. The first one, Robinson and Woolworth, we'll talk about for its explanation of how you should determine if something's improper, assuming it doesn't fit into one of the enumerated categories or specific forms of explanation, the more general rule, because we have a little bit more guidance when it comes to admissions, confessions, questioning. So Robinson and Woolworths is a case in which the Department of Health hired some teens, some tweens to go buy cigarettes and see if the stores would sell them. Bit of clarification post UEL to see if the same onus is applied that applied at common law. And here the Court of Appeal clarifies that the UEL didn't change the rule that the onus is on the person challenging the evidence to demonstrate on the balance of probabilities that there is impropriety. And they go through several factors which to the Court of Appeal supported that there was not impropriety in these cases. And these kind of get at the notion of entrapment. The authority was providing the opportunity to do the offense. They weren't really forcing it. It was a straightforward request in a public place. The girls they hired were acting very unusually. All of these factors militate towards this being not improper conduct on the part of the Department of Health. As to why Robinson was the party in this, which makes it sound and not the Department of Health, there was just some legal formality reason. I think the Department of Health wasn't a proper party to be on this style of cause. So more recently, we have the High Court decision, 2020 decision in Kadir. And this was a case about live baiting in greyhound racing. You might have heard of this. There was a Four Corners report on this. Live baiting is now illegal in every state. In New South Wales, you can see the Prevention of Cruelty to Animals Act, Section 21, which prevents this and similar activities. This is when you're training a greyhound to use live bait to motivate them, which seems pretty cruel. So there was a case against these trainers here, and there was really three sort of groups of evidence. One was surveillance evidence that was secret, covert video footage of them training the animals with live bait. It was produced by this person named Lynch, who worked for Animals Australia at the time. Animals Australia is a animal protection organization. And there's some question of if they were really concerned about this, why didn't they hand this case over to the police or to the RSPCA, who has some investigatory powers under the Act? And it sounded like from the decision that they thought that they had reason to believe the RSPCA was in cahoots with the Greyhound people. They would just tip them off about this. There's no issue of 138(1)A here, as there was in the Woolies case, Woolworths. It was well accepted that this was illegal. This breached the Surveillance Devices Act. So eventually they did go to the RSPCA, and then the RSPCA got a search warrant and found some physical evidence. And also Lynch, I think, just called. He admitted that he did do live baiting. So let's start with what the trial judge did. So the trial judge went through the factors in 138 and said, okay, it's very probative, it's very important to the case. This is very serious, it's deliberate. And as to H, which is the how hard it is to get this legally, the judge applied this in such that the more difficult it is to obtain the evidence, then that favors admissibility. So it's essentially it's a necessity argument. Like it's really hard to get this legally, you have to do it illegally, which makes it okay. And he found that the Crown had not really demonstrated enough that this was difficult to get legally, so they hadn't made out that arm of it. And then so they excluded it and went on to exclude everything else because it was of its connection to this to the first one. So he excluded it all. The Court of Appeal said, no, trial judge, you messed up. First of all, you shouldn't look at them in a group. You should assess each one. And if you do that, you can see that the first one, you should have admitted that one for sure. It's very grave, subsection D, and it's too difficult to get it without breaking the law. And then you go on to evaluate each one separately from there. This is where the High Court disagreed. And maybe you can see that sort of the reasoning in there. It's that it seems like any time that's really hard to get evidence, then the bad behavior is okay. And maybe that's not what we want to be encouraging. And so the High Court says no. Actually, that factor H that you thought militated towards admitting evidence, that in many cases will militate towards excluding the evidence. The fact that it's hard to get suggests that you are taking premeditated steps to break the law, to do something that should be hard to do. So Court of Appeal, you actually got this backwards. It seems to me that the Court of Appeal was taking a necessity perspective, that it's acceptable to get evidence this way if you have to, where the High Court was taking more of a deterrence perspective. That's confusing. There's more analysis earlier in the decision that goes over the difficulty of obtaining evidence under subsection H and how to apply that. They cite the Law Reform Commission in our favorite case, Bunning and Cross, which sort of seems to couch H in a theory of deterrence. And says that, it really depends on how deliberate the act was. If you're doing something that would have been easy to do, but you just don't care, then that makes it worse. But easy compliance might also indicate a lack of deliberation. That is not something we need to punish. It's an accident. So it really seems to be saying that H is a way to get at premeditation. It's not meant to say sometimes you got to do what you got to do. Rather, if you're doing something that was impossible to do otherwise, it's likely part of a deliberate scheme. And paragraph 20, the High Court further elaborates on this. It says there might be some cases where there's a real urgency and evidence will be lost otherwise. Cases like that, you might apply H differently, but in cases like this, where there seems to be this premeditation, it's going to be a negative factor. As to the search warrant evidence, this would clearly be inadmissible in the US, the search warrant and admissions evidence. They apply a stronger fruit of a poison tree doctrine, in which any evidence that's obtained through other illegal evidence is also legal. Here, the High Court makes it clear, and we already knew this from previous cases, that's not the rule that we have here. And it goes on to apply those factors to the admissions and search warrant, which I'll leave you to read. Okie dokie.